HB3440. Yes, thank you, Mr. Chairman, members of the committee. My name is Bryan Blevins. I am here today on behalf of myself and TTLA, and we are opposed to the bill. I'd like to point out a couple of concerns that we have with the bill and we shared with Representative Schofield. The first is that all of the information that's being requested in this bill is already required to be answered as part of the MDL's master discovery and or provided pursuant to Chapter 90, which governs this litigation. So the information that we're talking about is already required to be produced in the litigation. Secondly, so what this bill does is it flips the usual rules of pleadings and discovery on its head and forces the plaintiff, before they can file their lawsuit, to marshal all of their evidence. All of the evidence that Representative Schofield talked about, the duration, the frequency, the proximity of every exposure at every work site, for every employer, for every product. All of that is required to be marshaled before the lawsuit is even filed and produced not as just a narrative statement, but as to all of the supporting documentation as well. So it's a huge production of discovery well in advance of any other matter that we would see in the tort system. Also, the question is, who swears this? So in 99% of these cases, the decedent, the victim, is dead. So it's going to be their spouse, usually the female spouse, who is going to be asked to swear under penalty of perjury that this evidence is valid and just, when in fact she knows almost nothing from a personal standpoint, and this information, as Representative Schofield indicated, is developed from so many other sources about what evidence is out there and what products were where. The concerns about overnaming, which I understand are the fundamental basis for the bill, I can tell you that cases get dismissed for a lot of reasons, as Representative Dutton, Chairman Dutton, has pointed out. I'm not sure of how you would know a case is dismissed pursuant to settlement or not, because that's not going to necessarily be reflected on the dismissal. I can tell you that from our personal experience, my firms, we have filed 8 cases in the last 2 years, and we named between 3 defendants and 29 defendants out of a potential pool, as identified by the RAND study, of 8,025 unique defendants available in the litigation. We are suing between 3 and 29. I took a survey of the plaintiffs in the asbestos bar, and what I received from them was that in general, about 40 cases a year are being filed, and the defendants in those suits range from 1 to approximately 40. There may be examples of something beyond that, but in reality, there's no evidence, and I believe Judge Davidson will certainly talk to this, no evidence of widespread naming abuse. The questions of cost. With respect to how the MDL works, the plaintiff files their suit, the defendant files an answer. In that instance, it would be a 2-page general denial. Can't cost very much to file this. Then nothing else happened. The defendant would incur no further costs until the plaintiff files their responses to the master discovery. All of this information that is provided for, which covers all the requests that Representative Schofield's bill asked for. At that point, it's the defendant's obligation to respond to discovery, but it's master discovery, and most defendants will simply file a 2-page adoption of their already existing master discovery. At that point, the defendant can move for a no evidence motion for summary judgment under Borg-Warner, which is the causation standard in the state of Texas. Borg-Warner requires that you quantify by fiber and by fiber year for each product to hold a defendant responsible. And this is one of the reasons why defendants get dismissed. There can be evidence of exposure, but perhaps not sufficient evidence to meet the very high Borg-Warner standard, which is the highest causation standard in the country. Additionally, defendants would have access to typical rules of special exceptions. If they think the pleadings are inadequate, haven't properly stated a claim, as are required in every lawsuit filed in Texas, special exceptions could be filed. Also available to the defendant would be a motion to dismiss under Rule 91A. I don't know. We're apparently not going to have a representative of the defense bar at this hearing, so they could tell you why those tools perhaps are not being utilized, but those are available for them. So what's going to happen if the bill, with all respect to Representative Schofield and our concerns about, is this. The first thing that's going to happen is we're going to create barriers to the sickest of the sick. This legislature has legislated asbestos since 2003 actively, and the only cases being filed today virtually are cancer cases and mesothelioma victims. And mesothelioma victim is going to die within 18 months of the date of diagnosis. This legislature recognized that. And in recognizing it, this legislature passed a law that instructs Judge Davidson to get a living mesothelioma victim to trial within 6 months. This bill directly frustrates that goal, because instead of being able to file their suit based on reasonable appreciation of who they were exposed to, now that dying mesothelioma victim has to marshal all of this evidence before they can even file the suit and start the clock on the 6 months to get to trial. In addition to that, you have the appellate concerns, which are what happens if a defendant does not feel like the plaintiff has successfully completed the requirements of this bill, request dismissal. If they get it, the dying mesothelioma victim is back outside the tort system trying to meet the standard of this bill, get back in front of the litigation, try to save their statute of limitations. But on the other hand, what happens if the defendant is successful and the case is not dismissed, and then it goes up on appeal? Those are a fair summary of our concerns.
All right. Thank you, Mr. Blevins. Members? Yeah, Representative Schofield.
Mr. Blevins, I appreciate the fact that you came to my office. We had a nice discussion, as we always do, on these matters, and I appreciate you're always pretty forthright about what your concerns are. Not a lot of hiding the ball, and I think you'll agree I don't really hide it much either.
Yes, sir.
And so what I'm looking for today is to see, and we do have a witness who was signing up while you were testifying, who presumably will tell us some of the issues that they're having as defenses. But again, my concern is if you're getting brought into a number of suits constantly and you're never paying and you're never, you're not liable. And we talked about, the example I gave you was of the Dangerfield cases. I remember I had clients who, we're talking about toxic exposure cases, and they had provided desks and pencils to the plant, and they weren't getting out. Now, as you and I discussed with Judge Davidson, you get out, but you probably get very out. But by the same token, if you're being named in a number of suits where you're not liable and you're still having to pay people like me, that is a harm, as Mr. Wu pointed out, that you don't get back. And that's kind of the purpose of the bill. Again, we talked about, and the same thing I did talking about my layout, the fact that this is pretty mature litigation. By now, if we're talking about the Port Arthur plant, you could reach right down to your files and pull out who was there, which products and what years and all that kind of thing. So what's the burden? If you, as you said, you're going to produce it as part of the boilerplate discovery, and the last exposure was probably years and years ago. This is all pretty mature. What's the problem with just putting it up front and saying, here's where he was, this is where he worked, these are the people we think are likely at fault?
A couple of things. One is, while it is a mature tort, the litigation has migrated over years as defendants have filed for bankruptcy. And so a lot of the common defendants or historical defendants out of those plants where we do have that historical evidence have filed for bankruptcy and are no longer part of the litigation. We have now defendants that are perhaps play a smaller role, but not as well known, weren't sued in the past. Not every law firm has access to that historical database and wealth of information that my firm might have. But other
was that an advertisement right there?
Dude?
Was that an advertisement?
Can't say that. I've only filed 8 cases in the last 2 years. So if that is the case, then I'm not doing a very good job. And so other law firms don't have access to the information, but it's also a fundamental problem with who's swearing under a penalty of perjury, because how would a housewife whose husband's died, how would they be able to swear to the veracity and truth of all of this documentation that's been generated over 30 years of litigation, deposition transcripts from other cases, sales and invoices that might have been produced? Those are all a number of problems in terms of who are we having to swear. The other problem is...
You could ask the lawyer to do it, the guy who's bringing the case and who is, presumably researching it before he files it and not just suing people and finding out later if they've caused harm to his client. And again, in a mature field, we're not talking about something just happened today on something you and I never heard of. And we spend the next 2 years figuring out what it is.
Right. The fundamental problem, though, is that when I or any asbestos lawyer gets a case, they are looking at what were the years of work history, where did they work, what types of facilities, and what did they do, what kind of crafts did they do. And so I'm not going to know particularly whether or not Mr. Johnson was exposed to Dana gaskets or Garlock gaskets, but I know if he was a pipe fitter, then he would have been exposed to gaskets. And I know that Dana gaskets and Garlock gaskets are both utilized within the refining industry. So I have a good faith basis to sue both Garlock and Dana in my lawsuit. Discovery of the case, production by Dana and by Garlock of where they sold their products, testimony perhaps from co-witnesses that are identified by the premise owners who may be in the suit. These are all parts of the evidentiary picture that are going to come together. And that's the concern, is that, and we're doing this under a clock because we have a client who either is dying or who is dead, and now we're really struggling to find all of those pieces of information required by the bill, and we may be up against the statute of limitations.
Let me ask you one final question. You said you filed only 8 suits in the last couple of years in Texas. I assume you're not out of the business. You're filing asbestos suits in other states.
Actually, we don't.
You don't?
No, unfortunately, what's happened in the state of Texas, because of not so much the tort reform that the legislature has passed, but because of the Texas Supreme Court's in Borg-Warner, this highest causation standard in the country, because of that, Texas mesothelioma victims, almost 100%, are being referred to law firms in other states, in other jurisdictions, and they have to pursue their justice in those other states because Texas does not provide a fair home for their case.
I'll disagree with that. But the asking you if you filed in other states was a predicate question, and you may know the answer even if you don't actively pursue suits there, was if you have an idea of sort of the number of defendants that will be named in a Texas case compared to the number of defendants you're seeing in cases in other states.
And so what I can do is tell you what we've learned just since we've started looking at your bill, and I surveyed the plaintiffs' firms. Again, I can't say there's not an outlier here or there, but again, in my cases, we were filing between 3 and 29 defendants, whereas in the 90s, we were filing up against 70, 80 defendants. As to other members of the plaintiff bar in Texas, they reported to us that they filed between 1 defendant and up to 40, 42 defendants. I know that this is a bill apparently that's being pursued in other states and has been testified on in other states. I happened to watch the testimony of their representative, Mr. Behrens, who was promoting the bill across the country to different legislatures like this. He's from D.C., but he apparently knows all this stuff. And so he comes in and he says that in Missouri, for instance, the average complaint in Missouri had 83, 84 defendants. So twice as many as what the higher side of what you're seeing in Texas. And apparently there was one complaint in which over almost 300 defendants were sued. Now, again, I don't practice in Missouri, and I'm not going to tell you because I will say that who you sue is a function of what that plaintiff did, where they worked, how long they worked, whether they have premises defendants, lots of different factors. And there can be a justification for having a lot of defendants in a case. But that is substantially more defendants that are being sued, and I think viable evidence of why this is just not a problem for defendants in the state of Texas. And that would be my answer.
Thank you.
Members, other questions? Okay, thanks, Mr. Blevins.
Thank you so much. Appreciate it.